May it please the court, good morning. Michael Arado on behalf of the appellants here. I'm going to refer to them as the claimants. We're seeking reversal of the...
Would you like to reserve any time for...
I'd like to reserve 5 minutes, please.
5
Thank you.
minutes, you got it.
We are seeking a reversal in this particular case of the lower court's dismissal of the case with prejudice at a case management conference. And then alternatively, upon remand, another issue in the case was the denial of a jury trial. So procedurally, I don't think I need to go too much into the facts of the case. This court has already written one opinion on this case, and I think that's now the law of this case. Importantly, this court, in that opinion, held that the forfeiture statute entitled the claimants to a monetary claim. So that issues the law of the case, and that, in essence, resolves the jury trial issue. And that's straightforward, clear application of law.
Why is that? I mean, it just seems to me all that we held in the prior opinion was that the fact that this case was resolved at an adversarial preliminary hearing instead of at kind of a final forfeiture hearing after a probable cause finding did not divest your clients of the right to seek the statutory remedy for loss of value or loss of income. I can't figure out why it flows from that it has to be a jury trial instead of an evidentiary hearing before a judge.
Well, because loss of value and the other matters are monetary, not equitable in nature, and the test is clear here in Florida, that where a statute provides any type of right like that, that's not purely equitable, that even catch-all provisions, such as any other relief which could be allowed, and this court specifically allowed loss of income, which is not equitable. The test is clear. If it's not purely equitable, then a jury trial.
Isn't the test really kind of whether this is the kind of claim that would have been entitled to a jury trial at the time of Florida's admittance to the Union in 1845? I mean, that's... I mean, isn't that where the cases direct us to look on this?
I think that the cases are, I think the case law is pretty clear and straightforward. It says, and the cases are cited in my brief, particularly the Fox case. It says, it's the type of relief which is at issue in the particular case. And there is no question that forfeiture is an equitable matter. But we're past the forfeiture stage of this case. And the case was dismissed one time at all. And the equitable nature of this statute is not an issue for jury trial purposes either, because the statute provides what the Constitution would not. So for the forfeiture, the equitable basis of this particular statute, the statute says that has to be decided by a jury trial. So that's not the issue here. The claimants below here won this case.
Okay, I just want to make sure you are not making the argument that 932-7043 requires a jury trial on lost income, lost value. Where we're hinging this solely on Article 1, Section 22.
And of course, the case law, but I believe that the statute, insofar, the city's argument in this particular case for no jury trial was fairly straightforward. It says the statute is silent as to that. The legal paradigm which we have from the cases is that it's the remedy which is allowed. It's the remedy which is asked for, or which is permitted in the statutory context. It's specifically, the cases say, it's the remedy which is permitted by the statute.
Well, it's interesting because, as the city points out, the Supreme Court has held, at least in the context of rights to attorney's fees, that those are ancillary to the main claim, and that the jury trial right under the Constitution doesn't extend that far. To me, the structure of this statute suggests that the right to lost value, lost income is ancillary to the main forfeiture proceeding. I mean, on its face, the statute contemplates a resolution of the issue of whether the forfeiture is proper to be followed by, depending on whether or not the seizing agency decides to take an appeal or not, an award of by the trial court of lost value, lost income. Why wouldn't we kind of conceptualize that in the same way as the attorney's fees cases?
I think it can be, and in this particular case, that's applicable, and it's relevant to this case because, in addition, this court, in its opinion, reversing the dismissal of the damages claim initially, in its opinion, also awarded attorney's fees under the statute. And there was an evidentiary hearing held in this case after the reversal as to attorney's fees and attorney's fee entitlement. But that didn't resolve the matter of the loss of value or loss of income, which the statute also implies, also requires. Now, before this court's opinion in the prior case here, the statute had never been read to imply that. This court read that kind of loss of income or damages element into this particular statute. Just the avalanche of law on that issue is simply requires that there be a finding of a jury trial, because that remedy, the loss of income, is not equitable in nature. And if it isn't solely equitable, and more so in this case, construing this statute.
Well, I don't think it's true that every monetary remedy a statute creates, and that's where I think the confusion is. I mean, certainly, you know, if you had some tort claim for which the sovereign was not immune, you'd be entitled to a jury trial on that to the extent you sought money damages. But I don't think it's the law, is it, that every statutory remedy is entitled to a jury trial simply because that remedy involves the payment of money?
Well, what I can say about that is if you read the cases where there is a statutory kind of cause of action, which is created by a statute, not a common law right, but a statutory one.
Is this even a statutory cause of action? I mean, it has the appearance of an ancillary remedy.
This court, I think, held that it was that loss of income, and it's important to recall procedurally that this case was initially dismissed for the precise reason which it was now dismissed and now on appeal. It's that the city argued back then that the IRS had levied on those funds and those funds had been returned, and so there is no cause of action for loss of income. The court agreed. The court held that it was moot, dismissed the case. Appeal was taken. This court then reversed. Now we're back, and we had the issue of attorney's fees resolved because the statute does provide for those collateral elements, collateral remedies, and there was the issue of kind of trial level attorney's fees, and there was the issue of appellate attorney's fees as well, because there was a reversal. Those matters were heard at an evidentiary hearing before the lower court, not on appeal here in this case now. So that issue had been decided, whether there was attorney's fees or not, been decided. What was left was the loss of income and the loss of value that the statute allowed.
But Gonzalez 3, I think that's the way it's described in the briefs, the holding didn't necessarily imply that this is a separate cause of action. It's just that the fact that there had been no final forfeiture hearing did not extinguish the remedy. I need to know, I would like to know what your explanation is on how to hop to the conclusion you've reached, which that's a separate cause of action for loss of value and loss of income.
It's a separate right. If there was loss of value and loss of income, then this court held that my clients were entitled to recover that from the wrongful seizure. How do we get there? The city says an evidentiary hearing. In any event, that didn't happen in this case. An evidentiary hearing on the loss of value hasn't happened yet, and yet the case has been dismissed again. But that goes to the basis of the dismissal. There's no basis in law, in fact, to dismiss this case at a case management conference.
Could I ask you to clarify something for me? Do you believe there's been an adjudication that there can, by, you're saying the wrong adjudicator, a judge instead of a jury, that the fact that the IRS lien forecloses the relief of loss of value and loss of income?
I think that this court's initial opinion addressed that. The order on appeal in that case.
But at one of the many junctures described in the saga of this case at the trial court, did a judge adjudicate that the fact of the IRS lien
yes.
foreclosed return of the property, or did a judge adjudicate the matter of whether loss of value and loss of income were actually foreclosed by the IRS lien? Both, correct?
the judge adjudicated the latter, that the IRS lien, the IRS levy, there was no cause of damage there was no cause of action. It was mooted, the judge said, and denied that claim because there was a motion that was brought.
This is after it came back from the second DCA.
Before, that's what resulted in the first opinion, right?
No, okay.
So then, once it was remanded with instructions, then there was litigation. There was a notice of jury trial, which was the matter of attorney's fees was fully litigated, and there was an evidentiary hearing, and there were hundreds and hundreds of documents which were resolved. The attorney fee matter was resolved against the claimants in this case. That left the loss of income and loss of value, which is the only matter which is left in this case. The issue becomes is whether that is requires a judicial decision, adjudication through a trial by a judge after evidence, because there has been no evidence. No one's heard any evidence on this issue. They've heard evidence on attorney's fees. They've heard evidence on the forfeiture, whether that was right or wrong. Those have all been adjudicated. The only thing left is whether the loss of income, and if any at all, right? But those matters in our system are not adjudicated at a case management conference, and I understand the...
Well, let me ask you a question about that, and really what I'm interested in is the sufficiency of our record to address that issue. I mean, you would agree with me, I think, that the questions of whether this was within the trial court's power to do at a case management conference and whether your clients had adequate notice that this was going to happen at a case management conference, those objections are objections that would need to be preserved by having made them in the trial court, right?
I disagree with that.
Okay, you have any law for that proposition?
Generally speaking, the judge can set a case management conference, has authority to do that, right? And that is determined on its face, but then the dismissal requires a merits type of argument or notice, and those all come from the documents themselves.
Right. I mean, I don't disagree with that, I don't think. My question is whether or not you needed to make some objection in the trial court when the trial judge started heading in that direction.
So to preserve a specific objection that the judge ultimately dismisses your case at the end of, that you would have to say, well, Judge, you don't have the legal authority to do that in this hearing.
Right, or I didn't have notice that you know you were going to have this.
The notice and judicial authority to do what the judge did are matters of law, not matters of fact. There is no requirement of a specific contemporaneous objection during the case management conference in order to preserve those issues. The case management conference on its face presented none of these issues. None of these issues were raised in any of the records on the pleadings, and in fact the case management conference is not meant to adjudicate cases or resolve summary judgment or issues like that. Everyone concedes here, as a matter of record, including the city, that this was completely and totally unorthodox.
Assume for the moment that we disagreed with you on the requirement of preservation. We do have some cases, very recent, in the summary judgment context, where we have traditionally been reticent about saying you need a transcript of a hearing to show us what's going on. We have two very recent decisions in which we've said, listen, on the facts of this case, we've needed a transcript of the hearing to know that your objection was preserved because there is nothing else in the record that tells us that. Why shouldn't, to the extent preservation is required here, why shouldn't we have the same worry? In other words, how do we know from this record that the questions of notice and the trial court's power under Rule 1.200 just weren't abandoned or waived by non-assertion below?
Yeah, essentially it comes down to the type of proceeding which this was involved with. No one, practically speaking, brings court reporters to case management conferences, particularly when nothing is noticed on the case management conference and no evidence is taken at a case management conference. A transcript of proceedings is not simply required to preserve matters for appeal, and it's kind of hornbook kind of law. If there isn't, this particular case, and I will agree with the court, that in certain circumstances, a transcript is required. But from the face of this particular record, in the face of this order, at least with summary judgment, there's a rule which requires the person to state the basis of their motion. That's done in writing. There's a response period that's done. And so from the record, in this particular case, we had a consideration of waiver, latches, other pleadings determined as nullities, of which there was no notice that any of that was going to be heard. And from the record, it wasn't raised in any of the city's pleadings or raised anywhere else in the record. It was just kind of the trial judge's pet theory.
I'm sorry, and you've hit your 15 minutes. You're more than welcome to keep going. But
Thank you. I'll reserve my 5 minutes.
Good morning. May it please the court. Michael Schmidt on behalf of the Appalachia Tampa Police Department. Also present today is Robin Horton Silverman as co-counsel. Before we even get into many of the issues the court has already raised, I would remind the court that this is a case in which, in less than a year, the first stage, that being what the courts have called the seizure stage, was already completed. We know that there was no finding of probable cause. We understand that. But the case was concluded. The forfeiture stage was done. There was nothing left to do. There wasn't going to advance to a second stage, but for the fact that there was this ancillary issue of whether or not there would be any fees under 932-704-9B or 10 awarded to the appellants. That issue somehow is now dragged on for 8 years. And here we are again on our 4th appeal of this case. What's interesting is in 2013, in February 2013, when the court initially issued its order remanding this back to the lower court, never had the issue of jury trial on the matter of fees been raised. It hadn't been raised in front of Judge Padgett when fees were looked into by Judge Padgett, and ultimately Judge Padgett denied the fees. And it wasn't raised, in fact, until August of 2013, 6 months after this court's order remanding the case back. And at that point, the only motion that they filed, the only action that they had done, and remember that this is their burden of proof, it's their motions for fees, they are claiming they're entitled to it, and yet they're not advancing it. And in fact, in 2013, the record would show that what they've managed to do is repeatedly file motion for a jury trial, a notice of jury trial, typically when a lack of prosecution is filed by the court. And then they had their hearing. They got their hearing finally in 2015 after the city had filed motions to strike. The court had considered those. Judge Isom denied those, denied the jury trial, granting the city's motion to strike. And that leads us into Judge Isom's hearing. That hearing was properly noticed, and we know that for many reasons. One, in January, their own motion of 2016, appellants state that there is nothing left to consider except 932, 704, 9B, and 10. They've known the entirety of this since 2013 that these two issues were before the court. Yet, still, they didn't try to advance the issues. It wasn't until the city, Tampa Police Department, finally said enough is enough. We set it for a hearing. We don't believe it was ever our burden of proof. It was their burden of proof. They should set it for a hearing if they want these things heard. They didn't. And if you look at the record at 1761, a hearing was set by the city to help this get advanced, and clearly in page 1761 in the notice of hearing for Judge Isom, it states, this is for 9B and 10. We went to that hearing on June 15, 2016. This was their opportunity to be heard. They were noticed, they're heard, it's their burden. And what do appellants do for 9B? We have no transcripts. What happened in January 16 when we had hearings? We have no transcripts. What happened when the court considered the jury trial? We have no transcripts.
Well, the appellant had said that after this court made its ruling in Gonzalez 3 that there was no more adjudication regarding loss of value or loss of income. And I can't know what happened at that hearing, but the order said any further claims for damages are dismissed based on the record evidence that the IRS seized the currency at issue in this case. Therefore, the claimants cannot have a valid claim for loss of value or loss of income from the seized currency. So can this court assume that regardless of how it was noticed and regardless of what is being told to us by the parties on appeal, in absence of a transcript, the court considered the issue that they now want to be heard by a jury, which is whether they can get loss of value or loss of income?
I think there's multi-steps to this, Your Honor. I believe that first we don't get there because they were required to have transcripts in order to preserve this appeal. Second, by the time Judge Isom's order comes about, I believe that there was notice, opportunity to be heard on both matters. They failed to present it in front of Judge Isom, and Judge Isom's order came out in November 2016, denying the subsection 10 after giving a hearing to be heard on both matters, which they just failed to show any evidence that they presented any testimony, anything to advance 9B, even though it was set for a hearing. They abandoned it, and thus November 2016, Judge Isom enters a final order, and in December 2016, I believe this case was dead. They had 30 days to appeal it, they didn't. That's why in March of 2017, we filed a notice to the court that the case had reached its final disposition. We filed the final disposition form alerting the court we thought it was dead. Still nothing is filed by appellants, nothing. So I think by the time it gets to Holder, this case is already done and finished, is my, while I don't know that the court even needs to get there, if the court gets there, it's done in December of 2016 when they don't appeal. They had every opportunity. This is now putting them on notice. Hey, you've had the opportunity to be heard. Everybody agrees there was a court hearing. There was an opportunity to be heard. They didn't do anything to advance it. We think the case is done. A judge's orders come out. We filed our final disposition form. Still nothing. Then finally, 2018, another notice of lack of prosecution because the case for some reason is considered by the clerk is still open. Now it comes to Judge Holder. At this point, yes, I think Judge Holder looks at the totality of the facts, and he's putting it all out there on the table for multiple reasons why this case shouldn't still be open. And he's ordering that the clerk close the file. In addition, yes, he does go back and look at other reasons for why the case is closed.
Speaking of the other reason, would you agree that the actual procedures for dismissal for lack of prosecution were not followed here? The rule requires a 60-day period, not to mention the fact that there was actually record activity.
Well, I think what Judge Holder says was, Judge Holder says it was a nullity what they filed because the motion...
But there's case law saying that doesn't matter what if something's a nullity. We don't... The court does not look behind what was filed. Activity is activity.
Well, not only that, and I don't want to pile on, but I think on that issue, right, after the court's dismissal notice went out, the court entered a separate order setting a case management conference on the final disposition. And I think under the current rule, any activity is any activity, whether it comes in the form of court order or a filing by the affected party. I'd be interested in hearing you on that.
Okay. Then, again, and I do think that's why we, as Appellant has said, we have said it was unorthodox. And I'm not disagreeing that hearing stage was not the common way to get there. It's unorthodox, and the reason we got there was because, I would argue, because the appellants put us in that situation. The appellants put this case in a situation by not bringing their case forward for 5 years. And they had the opportunity. The case should have been closed. But yes, by the time it gets to Judge Holder, it's in this weird position of still being open when it shouldn't have been. Judge Holder has to determine what to do. So maybe I concede that it's not our strongest argument that notice a lack of prosecution, but that was only one of many Holder's points on this, on his order, our first argument for affirming Judge Holder's order is that we didn't need to get there. But assuming that we do look at Judge Holder's order, as the court has properly mentioned, we don't have any transcripts. We think they were necessary.
I will say the argument that Mr. Lorado makes with respect to the sufficiency of the record is one I had been mulling over too. What do you make of the fact that, just as a practical matter, this is a case management conference. This is not the kind of thing, arguably, that people ordinarily bring a court reporter to.
Well, this is a unique case in the fact that, again, that it's their burden. We're here in 2018, 5 years after the court's order, and Judge Holder calls it a final disposition, in all caps, bold, putting them clearly on notice of the hearing and what he intended to do and what it was intended for. It wasn't set for a summary judgment, nor should it have been, in my opinion. It was set because they hadn't brought forward a claim that the court had said, if you want to bring this forward, bring it, which is an interesting thing also because they've never shown that there is any harm. And we also believe that in the J case, J.V. Saxon, 720 Southern 2nd 214, they have to show harm in order to bring this appeal. We understand that they cannot appeal the denial of a jury trial because it's interlocutory, but the J goes on to say they have to show harm. By never presenting this when they had the opportunity in front of Judge Isom, they have never shown harm to even be before this court or before Judge Holder, as they later were. We do believe that transcripts are necessary for this court to determine not only what happened in front of Isom and whether they have tried to show harm, did show harm, didn't show harm, abandoned the argument, but in front of Judge Holder. We don't know what they argued, what they objected to, and because Judge Holder set it as a final disposition in all caps, they were present, they had the opportunity to be heard, and they chose
I'll be
not
honest with you, I have read final disposition in the order setting the case management conference as a reference to your final disposition form, not that he was going to conduct some sort of hearing to determine the appropriate final disposition of the case, whether that be by way of summary judgment or evidentiary hearing or whatever. What power would he have had under Rule 1.200A to do that? I think it's generally regarded that a case management conference under the rule is not the place to reach the merits.
I think, that is why we said this was unorthodox, because a case management conference, is this even a case management conference?
That's how it was noticed.
I understand that, and for those reasons we said this is a little odd, but that's because we don't think it should have been here, and the judge is trying to figure out, how do I get a case that appears to be closed from all the lack of activity? They've already ruled on the jury trial issue. They've had an opportunity to be heard on their 932, 704 arguments. There's nothing else pending. So the court is setting it, trying to get it set on the docket, just so it can figure out why this case is even open, and say, counsel, why am I even here? What are we doing here? Why is this case open? And so it was an opportunity to be heard why this case shouldn't be closed, as clearly noticed by the city thought it would have been closed, as court apparently felt it should be closed. I don't know what else he could have called it, but I concede that calling it a case management conference, as I stated, is different and unique, but so is this entire case and facts, and the fact that we're even here 5 years after they should have brought their claim forward. So I don't really have an answer to Your Honor for that, other than it didn't need to be in front of the court at all, and the court had to style it as something, and I don't see what harm they can call when they've never even presented their case to the court under 932 9B. They've never actually shown any loss of value after giving an opportunity, and I think Judge Holder is correctly pointing out that that's because there is no loss of value in reviewing the record that he had before him. It had never been presented, and so this needed to be finished. This was done on multiple reasons.
Go ahead.
No, please. Does the record tell us when the IRS seizure occurred? I was looking for that and couldn't find it.
We would have to go back, and I do know that, yes, I'm almost certain it would, but it's either going to be in around page 1400 when the city filed a response, a lengthy response to Judge Isom on whether the entitlement of fees. I go through extremely lengthy history there, and so I feel fairly certain in that 50 pages of history I covered that. Also, in the history of this case that Mr. Lorato provided, I feel certain early on that would have been covered at one of the hearings, although candidly I don't have that. I will say that also Judge Pageant's, on July 19, 2011, Judge Pageant conducted the hearing. It's probably discussed in there.
Okay, thank you.
So it sounds like, not to put words in your mouth, but what you're saying is whether or not there was proper notice of what might occur at the 2018 hearing, the last judge in the last hearing, as one of his grounds for dismissing the case, referred to a matter that had been previously adjudicated in your argument, and that is that entitlement to loss of value and loss of income was foreclosed by the IRS lien at a previous hearing, and so that no further adjudication of that matter was required, and therefore it doesn't matter whether the appellant was confused by what type of hearing it was. The point was there was no more entitlement to any adjudication of that issue before a jury or a judge. But when was that adjudicated? At what hearing was that adjudicated?
So, yes, partially that's what I'm saying. The IRS, that's why they couldn't advance 932-704-9B, and my argument would be why they chose not to advance it, because of the IRS levy that was in excess of the money seized, and they abandoned it at some point during this, even giving the opportunity. Why did they abandon it? Because of the IRS levy that occurred way back in 2000, I believe, in 11, in between the probable cause hearing and the second DCA, actually the levy had been in place a long time ago, obviously, before all this, but the levy was served on the police department during the first appeal. And the levy in the record shows it exceeds the amount of the $221,000 seized. So, that's when the levy was imposed. Now, why they didn't choose to go forward is with 9B arguments after this court remanded it. My guess would only be because they knew that they couldn't show anything or prove anything. They did do a motion for jury trial, which we are obviously in our arguments laid out that we don't believe is statutorily entitled to or constitutionally entitled to. And we believe that come June, after being given the opportunity, we believe Judge Isom's ruling come November 2011, the matter was clearly dead because they didn't pursue it in June. They had given up on that argument, having had the opportunity to present their case, their burden of proof. They chose not to. By December of 2016, we think the matter is dead, clearly. And so, yes, by Judge Holder's subsequent rulings, he's just going back and saying,
well, there's a mandate from this court regarding their entitlement to seek those
Right.
damages,
And-
after the 2011 adjudication you're talking about.
And they're we don't disagree, they're entitled to seek it. We just, where our disagreements are, is did they seek it? We argue they did. We argue they had the opportunity. and
When?
They chose not to, so if they decide to
At
abandon.
what post-2013 second DCA opinion hearing did they have the opportunity?
In front of Judge Isom, it was clearly noticed for a hearing, as I gave the site earlier. It was noticed that the June 15th hearing in front of Judge Isom was to consider 9B and 10. When we showed up at that hearing in June 15th, that was their opportunity. They chose not to argue 9B, or we don't know because there are no transcripts. Again, just another example of why transcripts were essential in this case. And what we do know is they never brought it up again until now.
And Mr. Schmidt, you're at your 20 minutes.
Okay, thank you.
Thank you. Mr. Lorado, you have 5 minutes.
Thank you, may it please the court. What we do know is the hearing that Mr. Schmidt was speaking about was specifically the claimant's motion for attorney's fees, which, as we know, statutorily, the forfeiture process is a two-step process. If you win the initial forfeiture, which was there was no probable cause finding, that entitles you to attorney's fees. Then there was an appeal, which there was also an issue of appellate attorney's fees. And under the forfeiture statute, there is an additional element of attorney's fees if upon a showing that of a bad faith, essentially. So what Mr. Schmidt or the city's main approach here is to conflate that attorney's fee hearing, which was, there was a motion, it was noticed, those motions for trial level and appellate level attorney's fees, which are decided by the trial court pursuant to this court's order as well. He's conflating those issues with the issue about whether the loss of income or loss of, I believe, loss of use or loss of value have ever been adjudicated. It has never been adjudicated in this particular case, and the notices of trial were aimed at that. And so these issues haven't been adjudicated. That the city may have considered the case over because the attorney's fees were decided against the claimant. That was only one portion of the case, and those were properly determined by the trial court, not an issue on appeal here in this case. Let me address the record. There's simply not a transcript that's required in this particular case because the legal positions of the parties are clear from the record, and a transcript would simply just be legal argument which was presented in the papers in any event as it relates to jury trial, and a transcript isn't required, nor is it as a matter of course.
With respect to jury trial, right? Under the forfeiture statute, these proceedings are generally regulated by the rules of civil procedure, right?
Correct.
So was your client or were your clients required to serve a demand for jury trial under Rule 1.430 at some earlier point in the case?
Not under the way that the forfeiture cases go. But I'd have to look at the record, and I think that there may have been one. But I don't want to speak not knowing the record, because the record here is voluminous. But the initial point I think that is important from the perspective of statutory construction is that the legislature has told us that although traditionally in equitable matters such as forfeiture, jury trial is not required, but yet in the forfeiture statute they provide for jury trial in the forfeiture aspect of the case. Now, before Gonzalez 3, as it's been referred to here, nobody's ever kind of brought this kind of claim before. No one even knew how it was to go. And so the city's position was that, if we lose a forfeiture, there's no further rights. So, but this court, in that case, issued its mandate and opinion, and kind of, I don't want to say created those rights, but said that the statute can be read for that effect. In terms of the jury trial, under Florida law, jury trial has to be decided in favor of a jury trial if possible. In terms of statutory construction, we know that at common law, equitable matters aren't tried to juries. The legislature in this case said forfeiture matters are. Did not say that the kind of loss of value, whether it should be or shouldn't be. But the question, or the statutory construction question, is resolved in favor of a jury trial because the legislature saw it fit to determine a jury trial in the forfeiture aspect. Why wouldn't it be appropriate in the loss of value aspect either? I suggest that it would be, and there's no other way to reconcile that with the canons of statutory construction or the other case law which have kind of construed acts similar to the Florida Contraband Forfeiture Act. For those reasons, we'd request that the dismissal be reversed and that the case be remanded with instructions for a jury trial on the matter of loss of value and the other issue there in the court. Thank you very much.
Thank you, Mr. Lorado.